Coming up on this program, we show you how to get connected, find out how to choose an internet service provider, discover the newest form of communication, electronic mail.
Ways down and ready to ride.
Hello everybody. I hope everybody's doing well tonight. I've missed everybody. Oh, Chuck, your name is always kerfuffling the chat. No, I'm just joking. My friends, thank you so much for being here. I'm so glad. I was only like 3 to 4 minutes late. That's very good for me if you know me, which you guys do. I have been super busy this week, and so I appreciate your grace and understanding as we navigate this. But we do have some court to watch and talk about, and I haven't seen it yet. I don't know if any of you have. I don't know if other channels have showed this yet. If you watched it by yourself, if you sat in your bathtub on a Monday drinking wine, listening to this court case, judging these people all by yourself, or not. Maybe that didn't happen. I don't know. You know. Anyways, I hope you guys are doing well. We are going to Thurston County. I did already scrub through this, not the case, but just the beginning part. So, because this judge is so slow. Also, is it possibly... No, Chuck, you don't go sit anywhere. Who wants to guess how many steps I've done yet today? It's a lot. And... Sorry, I need to focus. I need to focus on me. Doing the things that I need to do. I need to focus, Judge, so you cannot talk. If you could shut up, that would be great. Okay. Focus. Yes, focus. Just like this, Judge.
My cases, so just bear with me here on these. Okay. All right, so Mr. Valley, you have an objection to somebody being at the table with the petitioner. I see somebody is at the table with the petitioner. So Ms. Henry can tell me who that is and why they're there.
Yes, it's my advocate. I've been working with for 4.5 years now.
Okay. And when you say advocate, you don't mean lawyer, do you?
No.
You mean something else?
Yeah.
Can you tell me what you mean?
Just my advocate that I've been working with.
So helping you in other regards, not with your legal problems.
Yeah, not
okay.
with legal problems.
Okay. And why do you need him to be here with you at council table?
Just for emotional support.
Okay. All right. Mr. Valley?
And I said this with some trepidation, because the harder you push back against. And the last thing I want to do is incur the ire of Your Honor or any court. I bring this in good faith for a very important reason. This is all a smear. And there's no showing, and there's no nexus, to use the fancy pseudo-Latin word. There's no nexus between this. There's no showing. And it's also inappropriate to have anybody before the bar who's not a member of the bar. Thank you, Your Honor.
Okay, well, let's see if I'm more concerned in the context of a hearing like this, whether it's disruptive than I am anything else. People frequently have people at council table who aren't lawyers for various reasons, and I'm perfectly okay to allow it to happen as long as it's not disruptive.
Well, and I feel like I made the record, and including the point that underlies it. And it would be in the nature of a continuing objection if it was objectionable.
Yeah, I'm mostly concerned if people sit at council table who are acting in the capacity of lawyers and then trying to convince me through, artifice that they're not really, and they are, and I don't want to allow any kind of unauthorized practice of law, and I don't think that's what's going on here. I think I'm willing to let him, sir, sit at the table and, be of support, whatever that means, as long as it's not disruptive. Okay.
And Your Honor, just not to.
Buddy, this lawyer's going crazy. Carol, thank you so much. Members only will be this Sunday. And we will be live Friday, Saturday, Sunday, Monday. So don't worry. We got a lot of good stuff coming up. But this lawyer is feisty, to say the least. We don't even know what these people are freaking fighting about yet. But he is feisty.
Belabor the point, but I do intend to keep an eye out to see that I think even whispering or offering of anything would be wrong.
All right. So let's take this case up with an issue that I have, and I think you may have alluded to it at the last hearing. One of my concerns, is that this case here in front of the court now may have been subject to prior litigation that resulted in a decision on the merits and in another court at another time. And if that's the case, then obviously it can't be relitigated in the context of this hearing in this court. But that may not be the case. It may only just look that way because the parties have been to court before, apparently, in another court. So can we address that?
Yes. So I'd like to clarify that Thurston County Family Court told me they weren't the correct venue for the protection order. And I attempted to turn in my protection order anyway to them in hopes it'd be pursued over there in family court.
Mm-hmm.
And I ended up getting an email.
Cellulite yoga pants, are you serious? Oh my god. Holy fuck. I take days off and then this is what happens? Oh my god. And Mike, your roommate? Ooh, let's send good vibes. I gotta restart sending my vibes. I gotta start sending good vibes. I'm sorry. I've been vibe lacking. I'm so sorry to hear that. I'm being, sending you good vibes. Oh my goodness. Do you need anything? Is there anything we can help with? What's happening? A heart attack and then a stroke? Is he in the hospital? I would imagine so. I don't even know. My gosh.
Email stating like they're not the correct venue for it. And then I also asked district court here if they could clarify with family court if this is a correct court.
Mm-hmm.
And then they called over and they said that it should be handled here at district court.
Okay.
So I attempted at family court. I turned in my paperwork and everything.
Yeah, that's similar to what I'm talking about, but not quite exactly the same thing.
Yeah.
Which court the case should or could be heard in is a slightly different issue than whether the case has already been heard before anywhere. Okay.
Yeah.
And just for your benefit, really, because I know Mr. Valley already knows this, but generally, if a case has been brought by one party against another and it's been heard in court and a decision has been made on the merits of that case, then that decision is final. And the only way that decision can be reviewed is through something like an appeal of that decision to a court that has appellate jurisdiction. So then it's not permissible to at another time bring the same claim against the same party in another court. Well, in any court, but certainly not in another court. Okay, you get what they call one bite at the apple. Okay, so that makes any sense to you. So if you have, and that's why I asked the question, because I've seen by looking at the history of you and Ms. Lewis-Oxley, so the parties in this case, I've looked at that history of there being cases between you, and I've seen on the statewide computer database that it looks like there have been cases. Some of them have been, or at least one of them that I was concerned about was a protection order case And I do not recall now which court heard it. Maybe one of you can enlighten me on that, but I don't have my computer
I
system up here.
attempted a protection order in Thurston or Tumwater Family Court, and I provided 10 pages of documentation. And then today I have 116 I've provided.
I may be able to access this.
Or I have 156 pages altogether.
Okay, keep fingers crossed and maybe I'll be able to access that.
I can tell the court when that case was, and I have a case number too, but I'm also remaining silent until the court.
Yeah, I'm gonna follow up with you in just a
Both of
second.
you- If you could both remain silent while I say hi to Christopher Engleby, that'd be great. Carol, we don't know yet. We're learning together, just as we go. Hi, Christopher. I hope you are well. Cellulite Yoga Pants, you make me laugh. I like your attitude towards things. That's such a great way to be. All right, Judge, you want to take over? You got something to say? What is everybody whispering about? Whispering is rude.
It was due to insufficient evidence.
Do you have the case number of that case that you filed before?
Yes. Case number is 232-303-5734.
Okay, got it. That was a case in Thurston County Superior Court, May of 2023. Parties in that case were someone named Amare Carrington.
Yeah.
That was a minor. And then there was the petitioner was you.
Yeah.
And the respondent was Miss Lewis Hoxie.
Yeah.
Okay. That's an area of concern. Let's see what happened in that case.
That's not an area of concern.
Okay,
1
so
year, baby.
You tell me if you remember this. On June 28th of 2023, the judge presiding over that hearing issued an order denying the petition for a motion for protection.
Correct.
Okay.
Due to insufficient evidence.
Due to insufficient evidence, okay. Now, that's why I have a concern, because the material that has been submitted in your case,
Yeah.
The current case that we have here in this court looks like it was dated around the same time as the hearings in the Superior Court case in Thurston County Superior Court last year.
I provided stuff from 2014 to 2024 and many updated declarations as well. There's 12 declarations. So it was a total of
You guys
10
are the
years
best.
of this stuff going and not stopping.
Okay, so the material, let me ask it to you in a
NPC, thank you so much. First of all, I think so. Last night was quite the storm. There was wind a blowing and a blustering. Okay. I went to the gym last night. Yay me. And they have these planters that are probably 5.5 feet tall. No, 4.5 feet tall. But then they have plants in them. But they're heavy, you know, at this plaza. Like, it's a high-end sort of place. Not to brag. It's not a brag. It's just, it's like, anyways, regardless. When I was going to the gym, the wind was blowing them over. So they said it was like 90-mile-an-hour winds. But we didn't lose power. My daughter's dad at their house lost power for quite a while, but where I live is really near some vital infrastructure. So even if we do go down, they fix it fast, and I think they keep this area very well maintained because it's important that emergency services don't go down. So, but it's not coming to shore, I don't think. Like, wouldn't Ryan Hall y'all tell me? Anyways, I think it's fine. Yesterday was quite bad into today when I basically when by the end of the day it had seemed to calm down, but I'll check and see if there's still a weather warning. Thank you again, by the way. I love you guys.
Slightly different way. The material that you submitted for this court to consider in whether or not to issue a protection order, have you previously submitted that same material to another court in another hearing?
She attempted a fraudulent order against me right now.
I need you, but I know that you probably want to say a lot about the circumstances, but
Yeah.
just let's zero in the
No,
focus a little better.
That's why I'm bringing it forward for an anti-harassment order, because the other judge did not see all of this. No, she only had 10 pages.
10 pages.
Yeah, that I turned in, and today I have 116 and a 156 altogether.
I think that answers the question I had. I mean, there's a lot here and not all of it's dated, so it's hard for me to know.
What wasn't dated? I'm sorry.
Well, a lot of this is screenshots of texts and things like that. They don't have dates on them. So just looking at the documents themselves, it's not possible for me to say when they were generated or when they may have been submitted before.
Story of my life. No.
All right, Mr. Valley, can I hear your take on this, or I guess, an answer to my question about previous litigation?
Yes, I first I'll just note we spotted this issue as the court noted. So I have clear thoughts. It's just where to start. This case that the court just reviewed, the finding, the denial or the dismissal, that happened in June of 2023. So my argument is that anything from 2023 is res judicata. And my argument further, getting into the facts, as in the nature of an offer of proof that Ms. Henry has made, there's only one incident since Thurston County Superior Court dismissed a petition using the same evidence from 2014 to 2023. And I want to make this subordinate point or parenthetical point. To say I only gave 10 pages of evidence is to beg the question. You shoot your shot. That was batting practice. To allow someone to submit 10 pages of evidence, not succeed, and then submit 150 pages of evidence would be to allow batting practice, which we don't. That's exactly res judicata. But that's a parenthetical point that I presume the court understands and appreciates. So there's only one incident since June of 2023, and that's the encounter in the mall that amounts to nothing. It's an encounter, as I advised my client, and maybe I'm wrong, but I said, you should be able to flip somebody off in the mall. And I know that's crude and rude and socially unacceptable, but if the worst it got was mean mugging, and also I want to note something else that's drastically, I'll stick to the res judicata. What I was going to get at, though, was there's an underlying family law, and this is an end run around that. Amari is Ms. Henry's and Ms. Lewis's significant other's child. Verna Henry and Brandon Carrington are the parents of Amari, who's not seen his father in a long, long time.
They share a baby daddy. That was exactly what I thought. Oh, y'all ladies fucked the same man, and now you fighting over him. Girls, stop it. Stop it.
They had a settlement conference the day of our last hearing in this case, at which I'm not the lawyer in that case, but Ms. Henry's position is entirely positional. which negotiation 101, positional negotiation is the second to the least effective. So this is an end run around that. My final point is, and I'm going to be intellectually rigorously honest, as I always try to be. If I ever make mistakes, they're unintentional on my own. So this is a stack of far more than 10 pages that Ms. Henry filed, not as the petitioner, but in response to Ms.
Oh my goodness. Thank you so much, Christopher Engleby. I was thinking about you today when I saw cheese curds in my way. If I was more into cheese making, I could make that song funny. Anyways, thank you, Chris.
Lewis's recent case in Mason County Superior Court that the court denied before Judge Cobb denied. And anecdotally, my client told me he told these people to stay away from each other. Verna Henry lives in Lacey. Tia Lewis lives at Skokomish. They could not be further away. Yeah, of course they could, but my client would have to live in Brennan and Ms. Henry in the Nisqually for them to be further away and remain in the same counties they're in. So it's res judicata except for the August 2024 encounter at the mall, which does not arise to even a prima facie showing of harassment. So and now I'm getting all worked up, and I apologize for that to myself and everybody else, because it's much more effective advocacy to be slow and come up as if we were under the floor. So that's what I want to do. I think a res judicata dismissal is appropriate. And I didn't have time. I keep promising my client, I think this amounts to, and I don't even know the phrase, but the anti-slap. If I had had more time and more resources, I would have researched how I can proceed with my client to see to it that Ms. Henry stops this. Thank you, Your Honor. And also, there are two sides. I mean, everything she says, we can say back. Except for I think we have stronger facts in our case.
Okay, so the case you're referring to in Mason County, also between Ms. Henry and Ms. Lewis Hoxie. In that case, Ms. Lewis Hoxie was the petitioner and Ms. Henry was the respondent.
24-2-661-23.
Okay, I've got that case here. And in that case on September 27th, the judicial officer, not identified, entered an order denying the motion for a protection order.
Yes,
So it
absolutely.
looks like that was the same outcome as the Thurston County case the previous year.
And I could say, I don't know why we're here, but I do. We're here because of Amari.
So,
and there's no allegation even, except for Amari was at the mall with them. But any of these to 2014, Amari is a collateral damage, but he's also the driving force. It's a 6-year-old boy wagging the dog.
right, Ms. Henry here, you know, my concern is, as I've said, that this case has been heard before. Okay, just to keep it as sort of, you know, straightforward as I can say it. And, you know, Mr. Valley's correct. Even if you went to court before in Thurston County Superior Court and you gave the judge there 10 pages of information that supported your position that you should have a protection order, and the judge listened to all that, listened to what you had to say, listened to what she had to say, made a decision and decided, no, I'm not going to give you a protection order for whatever reason, sent you out of court with an order saying, no, you don't get a protection order. You can't then go, gosh, there's a whole bunch of other stuff I should have told that judge and I didn't. Okay, there's way more information that I wish I had brought, because I'm sure the judge would have made a different decision had she known that there was all this other stuff. And so you get all that other stuff, put it together, get the how many pages it is, how many pictures or text or whatever it is, and you put that together and go back to the judge and say, Judge, I know you just decided against me, but here's all the other stuff that I wish I had given you, that if you had known about, you would have made a different decision. Okay, you can't do that.
So could we consider 2023 past
Well,
June and up
here's
since
what
it's
we
not
can
so?
consider. We can consider stuff that has not been litigated before between the two of you. that includes not only the information from the Thurston County case where you told me you submitted 10 pages, but also probably the hearing that was conducted in Mason County in September of this year. Okay. That may or may not be 100%. That's a slightly different issue. But what I'm saying is, if it's new, you can present it here, right? If it's new.
Yeah, and I have that.
So in your estimation, what I'd like to do is have you identify for me what's new. And then I'll consider that, the new stuff. And the new stuff may or may not justify issuing an order. I don't know. I'll hear from you, and then I'll hear from Mr. Valley on Miss Lewis Hoxie's behalf and make a decision. But what's new from what was submitted to courts before?
So Miss Lewis has been coming to our home, banging on our door, and she has threatened my daughter and then tried to grab my son. We've had to relocate. And the previous landlord, I've provided proof of her knowing and aware of the safety issue, as she attempted to help us break our lease to move. Safety locks changes. And then they accessed my address illegally since I was signed up for TANF. Her mother-in-law works for TANF. Her mother's supervisor has an email. I'm included as well. And then the same month, Miss Lewis was asking for a protection order, a picture of her vehicle at our house, and a picture of her still bashing me on social media. The same month she asked for a protection order. And then the same month as well, I provided a screenshot showing her saying, working on my sucker punch, still got a ways to go yet. And then this is Brandon's ex-baby mama, if you know, you know. There's other people who have also shown up to my home.
Your Honor, I'll object. I don't think any of this is new, and there's not been an offer that it's new.
Well, I'm following along here. And
It's all
if the
dated.
declaration that she submitted in her petition is the same information that she's telling me now, this is all in the record already.
All this stuff from August. And then I also have witnesses who have seen it, neighbors as well. And then I also have someone who always drives with me everywhere. So I have a witness to any assault or harassment.
Yeah, you filed declarations to that effect too.
This is the only time within the last 4 weeks where she has not tried to assault me, show up to my home, or threaten me.
Your Honor, that's perjury. I object, and there's no foundation, no basis for that. I know it just came out of her mouth, and that's also news to us, and there's no basis for it.
Yeah, I'm looking here in the declarations that Ms. Henry filed, and I don't see allegations like that.
This is all out of whole cloth, Your Honor.
No, this has been going on since 2014. I was 14 and Miss Lewis was 17.
And I'm going to
now
object to
25.
the, I know, I wrote it down 10 minutes ago when she said this stuff has been going on for 10 years. I object, and I know the court can separate the wheat from the chaff, but I object to the use of the phrase, this stuff. There is no this stuff. And that creates momentum and becomes a snowball. And that's why I object at the very beginning. This is all a smokescreen, including the DV advocate.
I've been assaulted 7 times.
I object and ask for some offer of proof.
I've provided one.
That's not race
directly
judicata.
from Miss Lewis.
So this is a good example. You told me that you've been assaulted, and I assume you mean by Miss Lewis Hoxie.
Yes, and
Okay.
she also has her
And
friends.
so when? And then point me to the place in your declaration and supporting materials that refers to that talks about that.
I've also here. In my declaration, it states, I have endured 7, almost 8 assaults attributed to Miss Lewis.
As part of your declaration.
Yeah,
When did those assaults occur?
all throughout the years.
See, that's a little bit about what I'm concerned with.
Mm.
Because when you, and without even evaluating whether it happened or didn't happen, okay, just putting all of that aside. If that's been brought in front of a judge before, and then the judge rendered a decision, okay, the judge decided, in Thurston County, the judge decided a year ago, in Mesa County, the judge decided in September. And the important thing is that if this has been heard and a decision was issued, regardless of anything else, I can't then hear that as if it's a brand new case and make a decision on it.
Even though I turned this in to show Mr. Cobbs like why her order needed denied and was fraudulent.
Yeah, that's when Mr. Valley, you may have heard him say the words res judicata. Okay, that's one of those legal principles that kind of stays with us all the time in the law. And even though, you know, I don't expect you to know it, and it's not your fault. There's no, you know, no criticism is being directed at you for not knowing that. That's something that people go to law school and spend years studying, and books are written about it. Okay, don't get too bogged down in that. I just want to
talking
make
about
sure that you
the
understand
race
it this way. It's like, it'd be like a sport.
Basically, it means that you can't go after it again when the merits have already been heard by a judge finalized. So it's the same principle as double jeopardy in criminal court. And in civil court, there's a presumption that you get one bite at the apple. That's why lawyers strategize when they sue people and where they sue people. It's like, duh.
Sporting event, you know, where parties, you know, two different teams played a basketball game or something like that, and then one team wins, one team loses. You know, there's a referee in the game, and the referee made a bunch of decisions about whether the baskets were legal, whether fouls occurred, all that sort of stuff. And then, you know, afterwards, the team that lost the game looks at all the tape, you know, and did the video and says, well, that wasn't really a foul that we got called, or there's a foul that should have been called in our favor. That basket wasn't legitimate. It shouldn't have been counted. It like that, right? And if you look at all of that and you think, gosh, we should have really won that game because there were some bad calls in there, or there was some, you know, there was some cheating that the refs didn't see. You know what I mean? Things like that. You can't then go back to the refs and say, see this video of the game, you have to call the game a different way now and award the victory to my team. That's sort of what I'm talking about, only in the legal sense. It's that was an analogy, just so that you could see that once it's done, it's done. Now, in your case in front of Judge Cobb, or your case here in Thurston County last year, if you didn't agree with the outcome, if you came out of there and thought the judge made the wrong call, there was good evidence in my favor that the judge didn't consider correctly, or the judge didn't allow me to present evidence into the record that the judge should have, then you can appeal that decision to a higher court, and a higher court can look at that and they can review it. And if they agree with you, they can order the original judge to do it again. But it appears from the record here that you didn't do that. Instead, what you've done is you've filed a new petition with many of the same allegations in it and brought it to this court. That's what you can't do. And I had that concern from the very beginning when I looked at this case.
So if they don't take this at the family court, how am I supposed to get it? Since they said insufficient evidence and I provided that.
When they heard the case before, you mean, when the judge said that the evidence was insufficient?
So when me and my children aren't safe, what are we supposed to do?
Well, here's what I could say about that. If you don't feel safe, first and foremost, you can call 911 for law enforcement protection. Don't even consider whether there's any kind of a no contact order, protection order. It's irrelevant. If you don't feel safe, you call the police. They will come, and they will tell you that they would rather come and not be needed than not come if they were needed. So you do that to protect yourself for sure, regardless of what I tell you here about protection. And then what you can also do is, if you believe that you have been the victim of harassment, stalking, domestic violence, whatever, you can go to court and you can ask the court to issue a protection order. I am absolutely not telling you that you can't do that. I'm just telling you that if you do it and the judge makes a decision, that's the decision. Okay. And it's not subject to just bringing it back and asking a judge or even a different judge to look at it again. That's, the law just doesn't allow for that. And I think, and this is where I'm willing to be wrong in the sense that if I misunderstand, tell me. I think you have been heard previously on this issue. And I can't offer you another opportunity to be heard again. What I can do is offer you an opportunity to be heard if it's a new case, if it's genuinely a new case, something that has arisen from acts and circumstances that were not known or didn't happen before. If it's new, we can hear new. That's
And
okay.
that's what I provided to Mason County, which is why her order got denied. All of that was new. None of that was in the previous case.
Can you separate that out from the other stuff that you filed in this case
I
so
can
that
do that.
I know what it is you're alleging is new that hasn't been heard by the court before?
I can do that, Your Honor.
Okay. Is that something that you can do now, or is that something you need some time to do?
I'd be willing to do that right now.
Can I call another case while you do that? And then I'll check back with you and Mr. Valley afterwards, and
Yes.
we'll bring you back up here?
Yeah.
Okay. Are you willing to work with Mr. Valley on and show him what you think the new stuff is?
Yeah, that's fine.
Okay. Why don't you do that? And we'll call your case up again.
So many sirens going around me.
All right. So we'll come back to that case. Okay, so
Sure, Judge,
next,
you got all day.
next I'll call Marquez versus Frisbee and Burke. Okay, and you're Miss Marquez? Okay. Damn it. It's number 24-345.
What was that creepy whisper? Let's go listen to that. What did they say?
And you're Miss Marquez? Okay. Damn it. It's number 24-345. All right, and then I see logged in under Kyle.
Who had crooked ladder in the background of their bingo card for the Zoom call, guys? A crooked ladder. Either the ladder's crooked, the camera's crooked, the people are sitting on the floor on a bed. Jesus Christ, you cannot fucking write this.
Burke, it looks like both Miss Frisbee and Mr. Burke are there.
Yeah.
Is that right?
That's correct.
Okay. Okay, so this
We
is
are
Miss-
also having a witness
You
on
have a
Zoom
witness
as well.
with you? Okay.
Yes, I believe she is in holding at the moment.
Okay, so we'll get her admitted into the call. I'm just opening up my court file.
Did you get a chance to see all the evidence?
Mm-hmm. Yeah, everything in the court file. It's,
Quite a lot.
well,
It's also irrelevant.
just get it opened up. Here we go. There. There it is. Okay, so what we're gonna do is I will swear the parties in, and then Ms. Marquez, you get to go first. You get to tell me through your testimony, through your evidence and exhibits, and any witnesses you may have. I don't know if
I
you
don't need
brought
any.
And then after I've heard from you, then it'll be the respondent's turn. Ms. Frisbee and Mr. Burke, same thing. They'll testify.
Their witness was supposed to be
Need
my
to hear
witness.
I will hear from the witness when the time comes.
Fine.
But after I've heard from both sides, then I'll make a decision as to whether or not there will be a anti-harassment or protection order. Okay. During the time that the other party or anyone is testifying or talking, don't interrupt them, even if you think that they are telling me something that isn't true. All right. Keep in mind that you get to tell me your side of it, or you already have, and I'm expecting to hear different things from different people. It's normal. I may need to interrupt you to ask you questions to make sure I understand what you're telling me, and also to maybe redirect you towards making sure that we're staying focused on the things that are going to help me make a decision in your case. Okay, so can I have each of you raise your right hand, please? And do you each swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes.
Yes.
Okay, Ms. Marquez, go ahead. And keep in mind that everything that you filed, I've already seen, and you're not required to repeat all of
Okay.
it. Yeah.
So I lived in the apartment before they have.
Mhm.
I known their mom and his brother before they ever moved in. When they moved in, we had posted like things up on our free group, and we gave it to them, so we never had a problem with them when they moved in. And then one day Kyle just started like giving us problems, and then the wife followed after. We never had a problem with them. We gave them whatever they needed for their new baby that came then. And then like the harassments just kept getting worse. So I had talked to my property manager. So she advised us that it's a civil matter to just call the police. So that's all I kept doing, was every time they harassed was to call the police. We have police records. One of their evidence was my calling to the police. That was my police report that they had filed as their evidence. Yeah, it's just an ongoing thing. I saw their evidence that they had provided. They're all irrelevant. I don't understand how me parking in my parking spot is an evidence as harassment. I mean, I'm in my parking spot. The neighbor is half into my parking spot. I don't understand how that's relevant to our harassment case.
Which apartment complex are we talking about?
Evergreen Vistas.
That's right over here.
Yes. He also provided like the parking permits. I've been there before him, and I have my parking permit papers that's my parking spot with my parking number
How long have you lived there?
since 2021,
How long have they lived there?
a year after, I think.
So they've been there maybe around since 2022.
Yeah.
So
something like
you've
that.
been neighbors there for approximately maybe 2 years?
Yeah.
Okay. How long have the problems been going on?
Ending of that year, 2022, when they moved in,
Mhm.
ever since then.
Okay. Now, and you've used words in your petition, you use the same words that they've harassed you. Okay, you said that to me a minute ago. You wrote it in your petition too. Other than saying they harassed you, tell me what it is they did or said that in your mind makes it harassment.
So like the words that they say, the name calling, the vulgar language,
And then I also submitted the picture of her with the baseball bat. I don't know if you saw that. We were all walking in. They live literally right across our apartment.
Yeah, you have submitted evidence that I guess it's not organized and it just is labeled.
Yeah, it was
like
organized on my
evidence.
flash drive, but I guess when they put it in, it was all.
Well, there are numbers next to them though. So there's like evidence 70, evidence 7, evidence 67, like that. Which one of those is the picture of her with the baseball bat?
I have no idea. They just told me to format it 1 to whatever number it was, and that's the way it was on. I have the flash drive right now, but that's how it is on the flash drive.
That's clearly not it.
I think the pictures are the first ones, if I'm not mistaken.
They have some facial tracking camera on their Zoom or something. I've never seen it do so
Okay,
much.
so in your estimation, and what you've told me is that the harassment comes in the form of name calling and vulgar language. Right? Anything else?
It's normal harassing, like the way they.
What about the parking?
I don't understand why he would even take a picture of my car.
But is the parking situation like a source of the conflict between
No, that's
you?
what I'm saying. Like he provided evidence of me
Mhm.
parking in my parking spot. That's irrelevant to the harassment.
Okay,
I don't understand why that's even needed in there.
okay. Fair enough. I just wanted to make sure I didn't hear you say something you didn't actually say. So you just clarified that
Yeah.
for me. Okay, understood. All right, is there anything else you want to tell me about this before I hear from them and hear their side?
There was a video he recorded when he was sitting in his vehicle.
I saw that.
So prior to that, I had called the police. We were up at the office. We have my kids go to Awanas. It's like a church club thingy. So every Wednesdays they have like dinner there. So we were up there. Prior to that was the incident with the baseball bat. I had called the police. I met Officer Hubner, and I forgot how to pronounce the other officer's name. Up there at the office. He came up and I was talking to his mom. The mom was leaving. This is the first time I've ever talked to the mom in person. Kyle's mom. When she was leaving, he banged on her car, and I had my old phone with the other messages, my phone broke. And that's when she said that Kyle told me to F off and I could die because she was talking to us. And then Officer Hubner was talking to us. We went down to our home. They followed us, just to escort us back to our home because they were outside. So when they came down, she started screaming from her windows and her dogs were barking. So Officer Hubner told her to control her dogs. And then we were down in the video. You'll see that we're down at the end. That's my apartment. We're in front of my apartment in that video where he's recording me talking to a lady and a man. So that's my apartment. The officer told us to stay at our apartment side and he would stay in his apartment side. He ended up going around and going into his vehicle to record us because we were near his vehicle. But in the vehicle, when he was recording, you'll see a phone that's recording us or facing my niece's window.
Can you tell me more about the baseball bat incident?
So we were walking in. So I live here. They live on the bottom floor as well, across us. So we were walking in. She's holding the baseball bat, and we were first. She was behind us, and she told my 9-year-old son at the time that if he doesn't walk faster, he's gonna hit him. She's gonna hit him with the baseball bat. So I turned around and I told her, "I dare you try." That's when I took the picture of her with the baseball bat.
I understand.
There's a police report too with that one, but we couldn't add in any more, evidence.
Okay, anything else you need to tell me?
Everything that they provided is just irrelevant evidence.
I'll hear from them and then decide that, okay?
No, I'm done.
Okay. Then Ms. Frisbee and Mr. Burke, I'll let you go now. You can decide between yourselves who's going to go first.
I will be discussing everything with you, Your Honor. So we actually only ever been here since April 2nd of 2023, exactly 1 month before my daughter was to be due. This actually, we were okay.
Hold on
we
a
were
second.
cordial.
Ms. Burke, hold on a second. I can't hear you.
Miss
There's a-
Frisbee, Your Honor.
Yeah, I'm
That
sorry.
would be my daughter. Give me 1 moment, please. Alrighty. Sorry about that. So her timeline is wrong. We've only been here since April 2nd of 2023. I was about 1 month before my due date with my daughter. Also, this, we were all cordial and everything. I don't know what happened. We really didn't talk to them much. We don't have their phone numbers. We don't have anything. We wave and all that. Then all of a sudden they start getting aggressive with us. And as you see with our evidence, they have withheld us from our own apartment. They withheld us from our vehicle. And I'm going to actually go back to the vehicle here in a minute. But everything kind of broke down a few months after we both had our daughters. And really, I'm tired of all the police calls she has made. The OPD report that we submitted was during a time my husband was in the hospital, and she all of a sudden calls saying that she's being harassed. If you read the police report, my husband was in the hospital the entire time this supposed harassment happened. She has made false calls several times for no reason. Also, on the date that we had the baseball bat was the day before or day after the Juanas, because I marked the dates on our evidence. The day of the baseball bat is the same day that her boyfriend at the time pulled a gun from the vehicle, as the picture stated, when I pulled in from picking up my daughter from her, I believe either the few days or a few weeks before Head Start ended. So I left and went back to my husband's work for the last few hours. So we were playing baseball with the dogs and all of that at his work, because his job's slow at times. That same day is with the baseball incident, not anything with the Owanas or any of that. So, and yes, we did have the police come over, and we explained to them, my cart is full, and you can see in the picture, I'm walking into my apartment. They are nowhere near. I never even talked to their children. I had my 3-year-old daughter and my pretty much, I think about a couple of months, it was a year-old daughter. My cart's full. So where am I going to place it? So I'm walking into my apartment. So we explain this to the police. They tell us, okay, you guys were good. No problems. They leave. The incident she's talking about at the Holanas is the day before, June 12th. And no, he did not bang on his mother's car. He just wanted to talk to them because we were starting to slowly become into contact with her. We were no contact with her due to potty training issues with my oldest. So just to show that it's not us harassing her, it is her harassing. But with the car incident, it shows that he's readjusting the camera is towards the sidewalk. We've had people slash our tires, and we had just recently had one of our radiator hoses and our hood jimmied and cut. So there are reasons why we had that camera up, and it was not pointed to their nieces or whoever it is window. It's literally across the sidewalk that is against the buildings, but no windows are in view. That video is showing how disrespectful they are by not getting off of the vehicle. They were leaning and all of that. And with the parking thing, they legally have no parking spot. We are all assigned a parking spot, and you have to have a
not concerned about the parking. Maybe I should hear from Mr. Burke.
Sure thing.
Yeah, Mr. Burke, what do you want to add to that?
So from what I'm seeing from the text messages that I've read between her and my mother, all this actually seemed to get out of hand when I took my new job as a credit manager at Rent-A-Center, where I did not know at the time, were
Humble brag, a credit manager at Rent-A-Center, and that started all of this. As it will. But guess what? I mean, did he rent the ladder? Oh dear.
customers. I work all the way in Yale. I work a long ways away from here. And I've had to help other stores. But to me, all of this, them accusing us, I've looked at the evidence that they put in, Your Honor. They have a video of me walking my dog and texting my boss. Me sitting in my truck. How am I harassing anybody when I'm usually at work from like 6 in the morning till 7 at night? I'm gone. I've only got 2 days off a week, and I'm usually not even home on those days off.
And you told me at the beginning that you have somebody else here as a witness who you want to testify for you?
Yes, my mother. She actually has a state. We put in her statement too. She actually wrote a statement.
And that's, am I going to find that in the file?
It should be in the evidence, yes.
It's under Tammy's statement.
Oh, okay. It is Tammy the person you're talking about?
Yes, sir.
Okay. Yes, I do have that. Is Tammy there with you?
She's actually on Zoom in the holding area.
Did you let somebody in named Tammy? Oh, is Tammy the Motorola phone? Motorola?
I believe so, yes.
Yeah, if that's, so. Can you unmute yourself?
She's not very technical sound, just to let you know.
Okay. Well, I do have her written statement here, so it's not necessary for her to just repeat what she's already submitted in writing.
Did I do it right?
Are you Tammy?
Yes.
Okay. Mr. Burke and Ms. Frisbee want you to testify for them in this case. So before you do that, I'm gonna have you raise your right hand, please.
Okay.
Do you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And I do have a written statement here from you that was submitted by Ms. Frisbee and Mr. Burke. What else would you like to tell me?
My son and I were having a lot of problems. Some people were saying things to upset me, but everything's fine now. And they are, Renee and Kyle are always fighting. She's threatening him all the time and making problems. They're not even there. They're gone from 7 o'clock in the morning till 7 o'clock at night. And her, I want to say husband, wasn't husband, their boyfriend did threaten Kyle with a gun. Are you still there?
That's somebody you're talking about called, you said in your statement, that's somebody called Brandon who did that?
Yes, sir.
Okay, yeah, I see that.
At the time, that was the guy that was living there with her.
Okay. All right. Anything else?
I don't think so.
Okay. All right. Ms. Frisbee, Mr. Burke, do you have any other witnesses who you want to have testify?
No, that is everyone.
Okay. Thank you. Thank you. All right. Well, I've heard what everybody here has had to say about this situation. And I've also read the declarations and statements that everybody has filed, looked at the pictures and the videos that have been filed too on both sides. And my ruling is this, none of this meets the definition of harassment and there will be no order issued. There's clearly a neighbor conflict going on here, but this is not anything that the court can regulate. I certainly don't have the ability to make decisions about who can park where in an apartment complex. You're going to have to address issues like that to your property management.
So if they, after today, if they harass again, can I refile?
I'm not going to be able to give you any legal advice about when you could or should file a case like that. Right. So I do not find by a preponderance of the evidence that any harassment has occurred.
Are you putting up cameras?
The temporary order that was previously issued in this case terminates as of this moment. All right, and I've issued a written order to this effect. The court clerk will file this and it'll be available to all the parties in the court file. All right, and that will conclude the hearing.
So do I get a copy now or do I get it outside?
If you want a copy now, the clerk can make one for you. You can get one by email.
I'll get one now.
That looks like Michael's.
Next, I'll call Michelle Benton and Lori McGinley versus Byron Lindsay.
Anymore. Over there on my park. Sorry.
Get that, Tammy, please. All right, so Miss Benton, I see you there. And is Miss McGinley still with? There we go. Miss McGinley, again, good morning.
Good morning.
And then Mr. Lindsay, I see you there logged in. We've got separate matters here. There are 24-359 and 24-360. All right. And Mr. Lindsay, since you're the respondent in both of these, I think it makes sense to me to hear sort of both cases at the same time since they both were filed kind of together. I will, of course, make decisions, based on the merits of each individual case, but if you don't have any objection to it, I'll just hear both at the same time.
Well, they are individual cases, and 360 filed by Lori doesn't even have my correct name on it. So also, I don't have any clue as to who sent them these emails. And so you've got the wrong person in court today. And I mentioned that the last time I was here. I did file for an extension in order to get evidence. And I have filed PDR requests with DNR for the emails that they claim that I've been sending. And DNR, in my list of evidence that I gave you, it shows that DNR will not be able to provide those until January. And so I'm really just kind of left waiting for that evidence from DNR.
So you're trying to get some information from public records at Department of Natural Resources to help you respond in this case?
Yes, that's in both cases. I'm trying to get the emails that they're saying that I sent. So I requested those. And then I also have been in contact with this investigative team that has been sending them emails, and they also requested a PDR request from DNR, which won't be available until January, unfortunately.
Okay. So you said you filed a motion for an extension. Now, I don't see that, but that could very well be because of our statewide computer system crash that we've had the last 2 weeks. And so does that mean you're asking me to continue this case, or are you referring to?
I'm sorry, what? You've had a statewide internet crash for the past 2 weeks? And do you think that's normal? That's terrible. That's fucking atrocious. What are you talking about, Judge?
To an earlier continuance.
I was referring to an earlier continuance, but since the DNR cannot provide those until a later time, I was going to ask for an extension if you're not willing to dismiss the case based on all the other evidence that shows that it's not even me that's contacting them.
Well, if your request is to continue the hearing in this case, I'll need to ask both petitioners whether they have any objection to that and then make a decision on it. But before I do, could you give me an idea of what material you're anticipating getting as a result of those public information requests and how it affects your ability to present your case here?
Okay, so on line 19, I believe, and of my table of contents, it shows exactly what I requested for the PDR requests, which are the emails that basically I'm trying to get my hands on the same evidence that they're trying to say that they have. In all fairness, to have the same evidence in my possession, because what they submitted was just a communication log that has keywords and, you know, stuff that they want you to hear in it, but I'd rather actually have the evidence in front of me so that I can present my case.
All right. Well, I will then turn to you first, Ms. Benton, and see if you have any response to that request for a continuance. And keeping in mind, if the case were to be continued, the temporary order would remain in effect until the next hearing.
Thank you, Your Honor. I do have issues with this being continued because in my original petition that I filed on October 14th, it contains all of the emails that Mr. Lindsay is asking for in his public disclosure request, because that public disclosure request was sent to me at DNR, and I had to provide all of these emails, and it's the same exact emails I provided in this case. So he does have that information, Your Honor.
And Ms. McGinley, what's your position on the request to continue?
I would agree. In my petition, there are copies of all of the emails that are in question. And when I
DNR's Department of Natural Resources, these are the people that are in charge of responding to Freedom of Information Act requests. It's concerning that he seems to have gotten their details and then tracked them down. They've been issued public or temporary TPOs. I'm confused. Again, this to me is such a weird fine line because they're the plaintiffs, but this is evidently something that's happening in their line of work. And so to me, having worked in government before, I would feel like this would be handled internally, you know? I don't know.
Submitted the petition. There's several of them that are logged in that communication log as well. Yes. So the information is there. Those emails are out there in the case documents.
I did see a number of emails in the pleadings that were filed.
Being a public servant doesn't mean that you aren't entitled to be safe in your workplace. I think what I'm trying to say is, like, I've worked in basically positions where people get upset because of different issues, and you might be the contact person or the name that they respond to. And I'm saying that I would assume that it should be incumbent upon a workplace to protect their workers who are just in their line of duty executing Freedom of Information Act requests. It's totally different if they were like interacting separately, but like if that's what it is, then I feel like the government should be handling part of this as like a no, but they're the ones seeking the order, NPC, saying that he's harassing them. So that's all I'm taking it on. I just find that weird.
And I mean, as far as I can tell, without having any additional context or any additional testimony about them, they don't seem to cause any concern. And I don't know, Mr. Lindsay, are you thinking you're going to get something different from what they're describing as the emails they've already submitted?
Well, I believe that this team has been in contact with DNR and has sent many emails to them. And so to say that all of the emails that have been sent are in their evidence is just kind of guessing. I would like to see the bigger picture, and I would like to see what all has been sent. I would also like to say that since I've been in contact with this team, and you can see in my evidence of my emails back and forth with them, that they have, because of this court case, they have ceased all communication with Lori and Michelle. So basically, because I contacted them and said, hey, what the hell's going on here? Why are you guys contacting these people? Are you guys doing this in my likeness? Are you guys using my name? They said that they would stop all emails. So my guess is they don't have any more emails, and that this has all come to a stop to begin with. And what I'm saying is that I can't be responsible for another team who's sending emails to these ladies based on PDR requests that I made public.
Okay.
I made hundreds of PDR requests public.
Let me just kind of take one step back from the issue of a continuance and getting, any additional emails.
Okay.
Emails from the Department of Natural Resources or requests for public records, from anyone, it doesn't really matter who. Generally speaking, none of that kind of thing is going to be harassment or is even going to be particularly informative on the issue of harassment. So even if, let's assume, that in the first case, let's assume that there are no more emails. All the universe of emails is known and they're all already part of the record in this case. Then it doesn't really make sense to continue the case. If there are additional emails out there that haven't been submitted as part of the record in this case, and they're of the same character, in other words, requests for public information out of the Department of Natural Resources or emails in relation to requests for public records out of the Department of Natural Resources, is that going to be informative or make any difference in this case?
Well, it depends on what those emails are, and without seeing them, I can't really answer that. It does look to me like, this fired up right along with the election, and a lot of these emails, these guys are CC'd on. These are emails that are targeting Hillary Franz, and so to assume that all these emails that we have on the record are all the emails that this team is sending is, it's hard to say what's going to come out of that, but I do believe that I deserve to see what all has been sent. And there might be some stuff in there that would help me, but the main issue is that that's a different team and I didn't send the emails. So, the fact that I did look in 2020, I publicly disclosed like hundreds of PDR requests from DNR, and I made those public. And so during an election season, some team got hold of these and they're emailing. I know you're angry at the source because I made those public, but if you don't have evidence that it's me emailing you, and I read through them and I really don't really find stuff that's really harassing. I mean, some of it's kind of not very nice. But you guys are more worried about your jobs. If you read what you're saying in there, you guys are worried about your jobs. You're not worried about being harassed. You're not worried about going home. I'm in Idaho. I quit
Mr.
my
Lindsay,
job
let's
5
hold
years
off.
ago.
I don't want you to address anything to do with, I don't want you addressing them directly, and I don't want you addressing, their motives for any of this. What I do want to do though, since you raised it, and I think it's a legitimate issue, is if this, in reading the petitions in this case, I'm familiar with the prior history in this case. I know that there were prior anti-harassment orders in place in this involving these parties. And I know that they arose in the context of employment and workplace. Now, I know also that order has since expired by its own terms. Now, these are new petitions that are filed, but given the content of the emails and other information that has supposedly given rise to petitions, that those are, I guess, they're political issues. They're matters of public concern that have to do with the Department of Natural Resources. They are, I don't know, critical maybe of public employees and how public employees are performing their functions, and therefore matters of public concern. I'm a little concerned that that is being characterized as harassment because it's maybe difficult and uncomfortable information rather than being harassment in the sense of a course of conduct directed at a specific person to cause them harm. I'm extremely reluctant to consider the fact that a person is making public record requests of a department of the state government and publicly or openly criticizing state employees in the performance of their duties as harassment. That's got obvious constitutional problems with it. So I want, if this is going to continue, I want to hear from the petitioners the basis for their claim that Mr. Lindsay is harassing them sort of separately from the notion that he's potentially making a lot of public record requests and heaping scorn and criticism on public employees or elected officials. I mean, is that what this is about?
Are you asking me, Your Honor?
Yeah, and that's what I mean, MB. Like, to me, it just seemed odd that this would be the step that you would take. This seems to me like a work issue. If you are and I've worked in government as a public servant in a very similar role, collecting things for Freedom of Information Act requests, literally. My point being that even if somebody was emailing or talking about you, like, it might be bothersome and there may be some communication back and forth, but probably not. In the days before COVID, there would have just been a discussion in the office. Nowadays, there's probably some sort of paper trail about it, but every response I've ever gotten is don't worry about it. People are upset. That's not really, you don't worry about somebody being pissed off at you. It's a job where people are pissed off at you sometimes. And so it is sort of out of pocket that they've come to ask for this. Like, I thought that there was going to be some real harassment. You know what I mean? Like, if it's just the Freedom of Information Act request and his upset with their reply, then that doesn't constitute harassment at all. But what I'm saying is, I thought, based on how the judge was treating it to begin with, that there was something more here. And that's why I was confused. I was like, if he's done something like over the line, I think they would just call the cops, you know?
Sure, Miss Benton, yeah.
Okay, so what this is about is I feel like it's continued harassment that he started when he left the agency in 2019. I first started getting emails at the beginning of this year. It stopped. Let me back up a minute. When I had the previous order in place, it was a 2-year order. And during that time, the emails did stop. The beginning of the year, they started again. It started sending pictures of a firefighter in Eastern Washington that didn't even work for the Department of Natural Resources, saying, "Why did you kill me?" And these were directed at me. These weren't CC'd. It was directed to me. There was statements in his emails that said, "When you lay your head down at night, and you close your eyes, I'll be the last person you see." I take these as threatening. What does that mean? I also submitted additional evidence after our hearing on the 28th that shows that Mr. Lindsay does own the domain at truth.wa.gov.us. He set that domain up in November of 2021 using his name, using the Byron Business email, and also using the 2224 West Wind Drive address, which was his address that he lived at when this case first started in 2019. I do know that Mr. Lindsay has since moved in, but I feel like it's just a continuation of the harassment that he had done before. I feel these as threatening. He's trying to tell me I'm going to lose my job. I mean, all of these kind of different things. And I feel like he's not being truthful, saying he doesn't know who these emails came from. The evidence I submitted, I think, proves otherwise, that he absolutely does know and that it is him. And this is just continued harassment, the same as he did before. And making those kind of comments are really uncomfortable. And I don't know what he means by those. When somebody says, "When you lay your head down at night and close your eyes, I'll be the last person you see." What does that even mean? I do really feel like this is continued harassment, and I would like it to stop.
All right, Ms. McGinley, how about you and your petition?
I feel very similarly. I will go down the path of, it is harassing to me in that it brings up all of the anxiety and concerns and fears that I had back in 2019 when the other order was put in place, particularly those that come across as non-political. One of them was the first one that started this year, was simply the subject of relentless, no text, and that is an exact replication of an email that he had sent in the previous under the previous situation when we got the previous petition. There was nothing in that at all that was political about the commissioner, the DNR, or anything, just relentless. That to me is harassing. "Hey, I'm here. I haven't forgot you. I'm going to poke at you." That's what that felt like. Some of these others, as Michelle had mentioned, those that talk about, "I'll be the last thing you see at night." Word for word from the previous situation. Again, putting poking, harassing concerns back in the head that don't need to be there. That's not political. Okay, you've got political things to say, that's different. That's not political. Saying you will lose your job because we're going to give this package to the next commissioner. That's not political in my point of view. So those are the things that to me feel like it's harassing. I do believe it is him by voice, by tone, and by content of what came across. It's very, very similar, using the same words, buffoons, crotch rot, some of those crotch rot, sorry, I can't even say it. These are very common, similar terms that were used previously, which to me says this is him, his voice, it's his words. And again, same thing, I want it to stop. It causes a level of anxiety and concern that is not needed. For what purpose? I have no clue. Again, it's not political. I'm a state worker. It has nothing to do with that.
All right, Mr. Lindsay, what I'm going to do is this. I am going to give you your continuance. I'm going to take you at your word that you're going to get some additional information from the public request system, public disclosure request system that might affect your response to the petitions that have been filed against you. We're going to pick a date for that here in a minute. And then during the time between now and then, the temporary order will be extended in each case until that date. So Ms. McGinley, Ms. Benton, there should still not be any kind of contact between now and then. I'm doing this for a couple reasons. One is I want Mr. Lindsay to be able to adequately respond to these petitions. And if there is information out there that he doesn't have direct access to except through the public request system, then we're going to recognize that that might take a little bit of extra time and effort. In doing this, though, I'm also mindful, and this will be a factor at the final hearing in this case, that the First Amendment issues and comments on matters of public importance are, generally speaking, not going to be considered harassment. So the context that's unique to this particular case and the history between these parties may make what would in other contexts seem like political talk actually be harassment. I get that. I hear what the petitioners are telling me in that regard, but I do want you to know that we have to be, from this end, have to be extremely careful and mindful about those protections. So let's get a date.
Yeah, they could just change their emails and filter new correspondence requests and divert it to a different employee. There, solution at the root of the problem. If he wants he can have as many Freedom of Information Act requests as he wants. He's just assigned a different employee to be dealt with. And they are not on his periphery anymore via their job. And their job should facilitate that. And then if he still dug them out and found them and did that, that's getting problematic. Right? Yeah, give him AI. Or somebody like me. I don't fucking care. You can be miserable to me all day. I actually I pitched that idea when I worked at the government. I said, we need a phone line where people can call in and they can complain about whatever they want. And I'll listen to what they talk about. And we're not going to do anything about it, but they can talk to me about it. That's a real idea. I picked.
And Mr. Lindsay, give me a time frame that you think is realistic here.
Okay, so on line 30 of the evidence, it says that they will have a first installment ready on January 16th. Now, I can't imagine them needing several installments based on what I asked. So maybe a little ways after January 16th would be enough time for DNR to provide those.
Okay. The next court calendar we have after that is January 21st.
Okay. Okay, yeah, and I guess if they only give me one installment, I could get hold of you right away.
All right, I'm extending the temporary order. January 21st at 9 a.m.
Lori's on the ground in the Department of Natural
And
Resources
no
getting the trees.
further service of notice is going to be required. All parties are present in court and have notice of the court date.
Hurry up, Judge. I want to get back to that other case. Actually, I'm going to fast forward. Missed something critical. Good night, Chuck.
All right, back on back on the record on 24-366. All right, Ms. Henry, were you able to kind of sort and identify what information is new?
Yes, I removed all the pages that were included from my first stalking order at a Thurston Family Court.
Mm-hmm. Okay. And I'm just going back. All right, and did you share that with Mr. Valley then?
Correct.
So that he knows what you're alleging is new versus the information that's been heard before by a court?
Yeah.
Okay, and did you receive that, Mr.
I
Valley?
did, and it's not, nothing happened, Your Honor.
Okay, so what I'd like you to do is present that to me so that then I can see what the allegations are that are new.
Okay. So in the paperwork submitted, which was the persistent harassment and threatening actions, my doctor's notes from when Miss Lewis attacked me. And it shows the other witnesses and declarations of when I was assaulted.
Do you have it there with you
I have
in
it
hard
all.
copy? Can you just hand that to me?
Yes.
The new stuff, not everything, but
And Your Honor, nothing, what I meant by nothing has happened is all she did was take out, and this is what she took my notes, remove the 10 pages previously submitted.
Mhm.
So the facts are all still old.
Okay.
And I, to make this record clear, and I think the court has already intimated exactly this, I can't defend against this when it's a constantly moving target. So I'll leave it at that.
Just from her previous or my previous order of June 2023, I still have multiple pages, at least like 64 in the last year.
Well, to give her advocate
I
credit,
think
he's
you
sitting
just
there doing
handed
nothing.
me all of the same material that was in your petition, the whole packet, so to speak. I have that in electronic form.
Yeah, I submitted everything that I took out all the paperwork from my previous anti-harassment order to my purse.
Okay, so I won't need this hard copy. I can just hand that back to you and you can continue to use it there at the table. That's okay. All right, so I have seen and reviewed all the material that's been submitted by both parties, declarations, supporting exhibits, everything. So what I'm going to do is I'm going to decide the case based on those. So I'm going to give you, Ms. Henry, the first opportunity to argue to me based on the evidence that's already in the record, why you should get a anti-harassment order in this situation. And then after I've heard from you, Mr. Valley will present his argument on Ms. Lewis Hoxie's behalf. And then I'll make a decision as to, is there going to be an order or is there not going to be an order? And I'll explain to you why. Okay.
Thank you.
All right. So Ms. Henry, go ahead.
Do you mind if I read from a paper? So I don't.
You can, but keep in mind, it's already part of the record in the case. It's okay to call my attention to it and point out passages
Just
and
not the
things
same
like that. You don't really have to read everything.
Okay.
But I'll leave it to you.
Okay, Your Honor, you will notice my order was dismissed in June 2023 due to insufficient evidence, as I only turned in 10 pages. Today, after removing the other pages, I have 109. And then about 64, just including from the last year, from June 2023. Many of the paperwork documents show the assaults, threats, harassment, and witnesses towards myself and my family. This has been consistent from the age 14 to 25. And Ms. Lewis stated she will be a witness in trial and that I was aware she will be, but court records at family law and my PO box will show I've not been provided that information whatsoever until she just mentioned it today. I was not served any documents she's turned into court. I had to view them online this morning. Ms. Lewis also stated of multiple protection orders, which is false, and the court will see that I have one protection order against Brandon Carrington due to domestic violence, which was extended to 15 years. Ms. Lewis' claims are irrelevant to the fact that my family and myself deserve to be free from Ms. Lewis and her people showing up and banging on our door, threatening us out publicly and at our home, and taking personal photos of us and our names bashed on social media, as well as the fraudulent information spread by her and provided to a recent court, in which thankfully that was denied, in a separate county in which none of us reside, as all of our stuff has been heard in Thurston County. The judge clearly stated she mentioned many irrelevant things, had known many people from our declarations due to their past incidents, and how the harassment does need to stop. That's the third time the court has recommended Ms. Lewis behavior halt. I'm pursuing this order after her fraudulent anti-harassment order and documenting years worth of continuous dangerous and concerning behavior towards me and my family could never be in bad faith, asking for our safety from her harming us or our home or our vehicles. I'm hoping we'll be able to enjoy our activities with our tribe and with other friends and family instead of having to be fearful and avoid certain areas, such as certain areas in Thurston County and Mason County, just so we don't bump into them. No child deserves to be followed or made uncomfortable in their home where they feel compelled to relocate just to feel safe. No child deserves to think they will be taken away because of threats and inappropriate things being said by Ms. Lewis to them. I would like to make it known that I've always reported and documented many of the unsafe and harassing incidents for Ms. Lewis. Some of the documents to name and provided are a guardian ad litem report showing concerning and dangerous behavior in which the visitation facility workers would walk my young child and myself to our vehicle. Guardian ad litem also stating she's seen the physical evidence of Ms. Lewis threatening to harm me. Mason Clinic documentation from the doctor when I was assaulted by Ms. Lewis when she showed up to our private property with multiple people.
Your Honor, I object. This is all old.
Paperwork from Ms.
I'll note the objection, but I'm
Thank you,
gonna
Your Honor.
let her continue to.
Understood. Thank you.
Paperwork from Ms. Lewis herself stating false intel to police that I am a known aggressor, which as you can see on my record, I am not whatsoever. She accessed my confidentiality address and a false number provided through TANF previously. I'm a part of the confidentiality program, so they allowed me to not use my current phone number because her mother-in-law works with TANF, and I included that documentation from her mother-in-law's supervisor, Mickle. And I have proof from my landlords attempting to help us break our lease in order to move. I provided documentation for my child's supervised visitation at a facility, stating he was hiding from Ms. Lewis when we were in the same store. 12 declarations of the few people who have seen the ongoing assaults and harassment. Your Honor, if you put my anti-harassment order from the past and previous and my serious concerns in my declaration side by side with Ms. Lewis, you will notice her statements change drastically and directly copy what I have said in mine. Things such as her impacting my career, as I've had to move my job 2 times and I'm working towards college in a 3rd career, and that was almost put on hold due to her fraudulent order. My family deserves peace and to not live in fear. We've taken serious measures to avoid harm We've relocated 3 times. I've worked with Advocate a total of 4.5 years, in which they've helped me and my family with the security system, hotel stays to avoid harm,
Your Honor,
and
this
then
is
they helped me
irrelevant. I
with the PO
object.
box, so I wouldn't be harassed by Miss Lewis and her mother-in-law at my home. I stopped being allowed
I
mail there in
object.
order
No
to-
foundation to harassment by anybody at her home.
I'll note that and you continue. Go ahead, Ms. Henry.
Miss Lewis feeling the need to correct me for writing my children's last name and and me wondering how she'd possibly know them shows the stalking's nonstop, and it's concerning how obsessed she is to the point she feels the need to search that deep into my children's privacy. There's no way she'd know my children's last name. I'm not understanding. In her previous order for her anti-harassment order, she stated I'm a drug user and that I'm a gangster, which is not true at all. All of this has been one-sided, Your Honor. I've never tried to reach out to her. And I believe Ms. Lewis recently stated she worked in childcare since our last court date in order to avoid the anti-harassment order being granted in order to make her look better. I would like to see proof of her start date because that will truly help show she will do anything to manipulate the court system. Your Honor, I go nowhere alone, and I always make sure to have a witness and do my best to avoid being harmed and harassed. My children and myself deserve to feel safe and comfortable in our home and in outings again. I kindly ask if you help me by not allowing Ms. Lewis' persistent and obsessive behavior in which bring harm to my family. By putting most evidence I have forward, I hope it shows I have responsibility to protect my family from these outings. Ms. Lewis has orchestrated attacks against me, a fact she has openly acknowledged on social media and screenshots are provided from Ms. Lewis's Facebook on multiple
Objection.
occasions.
That misrepresents the facts, Your Honor.
Knowing my
Yeah,
children
no,
are always
noted,
with
but
me and
you
the
can
risk of harm
continue.
to them that has been done. The photos provided also demonstrate Ms. Lewis and her accomplices engaging in harassment, threats, and defamation on social media, as well as making false threats, including involving CPS, physical assaults, and
Your Honor,
disparagement of
she's going on and
character.
on and on. She got 3 pages left, single spaced, like 350 words per page. And she's added nothing. She's added no single fact. This is all conclusory argument.
Despite my efforts to avoid confrontation.
That's an objection,
and
Your
hoping
Honor.
to
Hold on a
behavior.
second, Ms. Henry. Ms. Henry, what I want you to do here is, essentially sum it up.
Mhm.
I'm familiar with all the allegations that are in the record. In other words, the statements, the pictures, the social media posts, all the things that you've already put in there. They're all there. I know you want to say them again because they're important to you, but it's not necessary for you to do that because they're already part of the record. So you don't, it's not adding anything to your case to say them again, but what they mean and how the court should interpret them and apply the law to decide whether or not to give you a anti-harassment order. That's the part that you should be doing now.
Okay.
And if you don't want to add anything else, you don't have to.
Okay. With the documentation turned in, it is evident that Ms. Lewis has committed multiple offenses, including a hate crime, telephone harassment, first-degree criminal trespassing, first-degree malicious mischief, stalking, cyber harassment, coercion, reckless endangerment, and harassment. Thank you for your attention on this one.
Thank you, Ms. Henry. Mr. Valley, you want to sum it up for Ms. Lewis Hoxie?
Please, Your Honor. First, and again, I don't want to be counterproductive and harm my client's case. When I say I would move the court dismiss this for unclean hands. The court caught Ms. Henry in a blatant lie in the first session when she said that this is the first time, this last week is the first time that my client hasn't attempted to harass her. And she had more or less, through her silence, admitted that was a lie. She lied when she said that she had never reached out to my client because the first document, and there was an acknowledgement and there was not a request for continuance. I did read the local rules. My client didn't get her stuff in 5 days ahead of time. And that's as much my fault as it is hers, because even though the court gave us 2 weeks, that time ran very quickly, no excuse, because there was no objection to it. The first document that my client submitted gives the lie to Ms. Henry's lies. It says, "What's up, bitch? Keep posting Amari's one could assume she means name or visual face, and see where it gets you. You're being, and I want to emphasize again, this is Verna Henry to Tia Lewis. What's up, bitch? Keep posting about my son and see where it gets you. You're being watched, and don't think any of us forgot where you live. This is a woman who says this woman's been harassing her for 10 years and also lied and said she never reached out to her. And there's much else that shows that Verna Henry's lying. And I know those are harsh words, but I had to sit here and listen to calumnies heaped on my client and they're all false. For instance, I'm not as familiar probably as the court is with all these exhibits, but I know there's one social media post where my client did say something about Verna Henry, and it's not harassment. But what is harassment is you're being watched. Don't think any of us forgot where you live. Think twice. This is still Verna to Tia. Verna, who says she never contacted Tia. Verna, whose petition I'm asking the court to dismiss because of bad faith, because of unclean hands, because everything she said to the court is either a blatant misrepresentation, a blatant and intentional misrepresentation, or an outright lie. Because she said she never reached out to my client, but she sent this, and I'm continuing this single Facebook message. Think twice before you cross me, because next, this is a death threat. This is felony harassment, and my client had good reason to believe she would carry it out, especially in the context of this message alone, because it ends with sleep with one eye open, bitch. And I'm giving emphasis to the word, to the cuss word that this woman threw at my client. And I'm going to go back to the middle of it. Think twice before you cross me, because next time will be your last. Again, death threat. And I'm going to interrupt myself. Ms. Henry, without any basis, talked about a hate crime, talked about cyber crime, talked about stalking, talked about assaults. There's no evidence that Ms. Henry ever called the police. I know that once this woman's significant other broke Ms. Henry's windshield with his left hand. And that's where she says she got a 15-year restraining order against him. I don't think there's any such thing as a 15-year restraining order. My client tells me no, that it didn't. It did get renewed after it expired. And I represented Mr. Carrington at some point, but Ms. Henry didn't even call the police then. She's never called the police. So you can't believe a word she says. But I want to finish reading that text message. After the death threat, it says, I'm so sick of your ugly ass acting like you won in life. Brandon, who is her ex and her current, Brandon never wanted you. This is intentionally hurtful behavior. Brandon never wanted you. You have him because he was left. You have him because I left him. That's what Verna says to Tia. So funny to watch you guys play house. Just leave my son, and I'm adding that word, those two words, my son. Just leave Amari out of it. Sleep with one eye open, bitch. Now, see, here's where, again, more bad faith, more unclean hands. This is an abusive process, because what this is, in her petition, she asks the court to preclude my client from having any contact with Amari. Oh, and that's an end run around that. She says it's proof of stalking and harassment that my client knows her children's last name, when that's another lie. Julia Cruz is not Verna Henry's child. Julia Cruz, her real name is Julia De La Cruz, and she is the daughter of the man, the 40-year-old convicted sex offender with whom Verna Henry is now, pardon me? Not sex offender. With a significant criminal history, felony history. She's living with Raul De La Cruz, who is the father of Julia De La Cruz. Yet Ms. Henry wants this court to order restraints on some having to do with someone who's not even her child and whose last name she misrepresented. I could go on, but I won't. I will finish with what I said at the very beginning. Ms. Henry has offered literally, she didn't even talk about the incident at the mall, which didn't arise to harassment. Which my client for the family law trial is in the process of getting from Westfield Capitol Mall, the video. And I'm not offering that as evidence. I'm just saying to demonstrate our state of mind, we're acting in all good faith because we are playing house. We are now together. We have a child, Tia Lewis and Brandon Carrington. And this is all barred by res judicata, Your Honor, as well as bad faith, as well as a lack of substance. Thank you.
Thank you both. Okay. I appreciate you taking some time to addressed my initial concerns about it, because it's important that this court doesn't sit and rehear matters that have been heard by other courts. That's important for the court system, and ultimately the reason it's important is because it's not fair for people to have to go through court proceedings that they've already been through before. That's why I brought it up. That's why I wanted to make sure that we didn't essentially do that, because it's not fair to people. But I also, in an abundance of caution, I wanted to make sure that I wasn't accidentally keeping you from being able to present things to the court that you should be able to present to the court in order to make your case for an anti-harassment order, because it's equally important that you be able to do that. So that's why I was a little bit careful about this. And you probably weren't anticipating you were going to get dragged into legal issues like that that are more commonly addressed in law schools than they are in anti-harassment hearings, but they're important. So, Ms. Henry, the issue here is that I think that the way you are presenting what has happened in your relationship with Ms. Lewis Hoxie, you're presenting that to the court as harassment. And the problem is that the way common people understand the word harassment is a different thing than how the law defines harassment in order to cause the court to issue an order. Okay, so in real life, harassment is things like when somebody posts stuff about you on social media to drag your name through the mud, or trash talk you around town, or make you look bad in your community to your friends, your neighbors, the people who matter to you. That is not really harassment. What you're talking about there is, you may have heard terms like libel, slander, defamation. It's like that. Okay. Those are different legal causes of action, and they're not harassment, and they're not the kind of cause of action that can be brought in a district court. Okay. So I can't look at what you told me about the nasty things that she may have posted about you on social media, or made accusations about how you're an aggressive person or something like that. I can't consider those as harassment because they aren't. Harassment means something different. It's a willful course of conduct directed at a specific person that seriously annoys and is detrimental and would cause a reasonable person to suffer substantial emotional distress and serves no legitimate or lawful purpose. And I have to keep in mind in evaluating that, one, constitutionally protected speech, because people are allowed to say mean, nasty things about you. That's the world we live in. And it does not prohibit people from being rude, overbearing, and obnoxious. Okay. Now, she may be all of those things, and that still wouldn't bring it within harassment. Okay. So in this case, based on what I see here, even before I start taking out the things that have already been adjudicated by other courts, it doesn't constitute harassment. I think I understand why the other courts didn't issue you an anti-harassment order or issue her an anti-harassment order, because this material isn't the kind of thing that constitutes harassment. Okay? It's unpleasant, sure. It may cause you to have a different cause of action for damages, maybe. I don't know. But it doesn't entitle you to an anti-harassment order.
Even when they show up to my home and I have witnesses of that?
Like I said,
taking and threatening my stepdaughter.
Like I said, these things that have happened that you provide evidence of are not harassment. Taking into account the things that are not considered because they've been subject to previous litigation, it's even a weaker case of harassment. So for those reasons, I'm going to deny your petition.
Another big D from the judge, straight to her dome.
And I do believe there was a temporary order. Yes, there was a temporary order issued in this case. That order is terminated as of this moment.
a slept judge. Are they going to be okay with it? We're not watching the final case. We'll watch that on Friday along with some other new court. But I just want to make sure. Look at her shuffling her papers.
So if anything happens, just call the cops and hope they get there in time.
Well, I do want you to keep in mind what I said earlier about if your safety is at risk, it's always okay to call the police. Even if, if you think I got it wrong and I made a bad decision here and didn't issue you an order, that is completely irrelevant if your safety is at stake. All right, there's 911 and you use that. Now, if other things happen, if there's a course of conduct that develops, you are free to bring another petition for an anti-harassment order. You can present to the court anything that occurs that you think entitles you to an anti-harassment order. I'm not telling you you're not allowed to come to court. The clerk is making copies of my order to give to you, and then that'll conclude the hearing.
Thank you, Your Honor.
Thank you.
Always a pleasure.
She bolted.
Yeah, she said some of those.
Oh my God. What a crazy day for a judge over in Thurston County. I don't want to go to the gym. It's very late. The wind is not that bad now, but we shall see. I've already done almost 15,000 steps today. Ta-da! Keep an eye out for a Friday show. It will be fun, and we have at least one more TPO case, plus a few cases I've had up my sleeve that I want to share with you. I hope that you have a wonderful evening. Do me a favor, remember that I love you, and I'm proud of you, and I'll see you in the next video. And I miss you guys. Bye!
Ways down red.